Right, today we're going to look at the question, evaluate the way in which the Constitutional Reform Act 2005 has impacted upon the independence of the judiciary. Okay? Now what we're going to start off with is a kind of reminder really of what we should be doing with all questions, but we'll remind ourselves before we start this one. So the first thing to think about is the method of answering your questions. Make sure, as you answer your question, that you're linking each part of your answer back to the question. Okay? So make sure you do that. That's incredibly important. And keep checking that as you continue in your answer. It's so easy to just keep going on and on and on and not link back to the question. Try and create a strong framework. And this involves giving yourself a little plan. Okay? So a strong framework gives the examiner the impression straight away that you know what you're talking about. Now notice that this is 11 marks. 11 mark question is a mini essay. So immediately you need to think about how long you're going to give yourself to answer this question. Okay? So here, for this particular question, you would be talking about 20 minutes, no more. So you've got to be very concise in what you say. Now the first thing to do with any question, it doesn't matter what it is to highlight the command words, yeah? So what's it actually asking you to do? So here you can see we have evaluate. Think about what evaluate actually means. Evaluate is in essence looking at the strengths, weaknesses, advantages, disadvantages of what you're being asked to look at, and in this particular case obviously the impact of the Constitutional Reform Act. So that's a very important one, and that involves critical analysis, okay, critical analysis. Another command word you've got is impact. So what changes have been caused by the enactment of the Constitutional Reform Act? And in particular what you're being asked to relate this information to is the constitutional doctrine of the independence of the judiciary. Okay? Right then. What else do you need to do? Well, when you're answering any questions, remember to P. So point, evidence, explanation, evaluation. That's what I'm looking for you in your answers in every question that you do. And always give sources. And so sources, evidence to back up what you're saying. So those sources may be in the form of legislation, they may be in the form of a theorist, they may be in the form of a case law. You've got to include it to be able to get into the higher mark bracket, okay? So you've got to do that. All right then, so let's go to the introduction. So your introduction, as I said, we want to make it really strong and we want to make sure that we're actually answering the question, not just saying everything you know about some of these command words. Okay then, so we could start off with, in our introduction, that the Constitutional Reform Act 2005 has been particularly important in 4 ways. First of all, in relation to the role of the Lord Chancellor, the appointment system for the judiciary, the creation of the Supreme Court, and in fact, really assisting with rules of natural justice within our judicial system. We would also note there, possibly, that this act was particularly important because it put the idea of judicial independence into statutory format, and this is really the first time in 900 years, so that's incredibly important. So that's your introduction. As you can see, the examiner will already think, okay, they know what they're talking about here. Okay then, so now we're going to look at the role of the Lord Chancellor. Now the role of the Lord Chancellor threatened the independence of the judiciary because before the Constitutional Reform Act of 2005, the Lord Chancellor was in each of these different sections. Remember the separation of powers as advocated and put forward by Montesquieu. So he was appointed by the Prime Minister, he was acting in the House of Lords, and he was also appointing the judiciary in the higher courts, but also was sitting on cases. So the independence of the judiciary, we could say, was interfered with by the Lord Chancellor's strong link to the government. And please read the notes to go into a lot more detail. So the next part is the appointment process of the judiciary. Before the Constitutional Reform Act, the Lord Chancellor was involved in all the decisions on appointing judges in our system. This was thought to be a very secretive system. We had things such as secret soundings. So you had people employed as judges in a very closed way, which of course goes against our democratic system. If we look at it in relation to the question, independence of the judiciary, perhaps there was too much independence and it wasn't an open system. So now we have, since the Constitutional Reform Act, we have the Judicial Appointments Commission, which has taken over the role of the Lord Chancellor in actually appointing judges. With the Constitutional Reform Act of 2005, we also had the creation of a Supreme Court. Now this happened in October 2009 and really assisted us with the independence of the judiciary, because it took what was the House of Lords, which was located in the Legislative, and created a new building, and actually now is a separate building. It's in the Guildhall, and that means that the justices are within the judiciary and not part of the Legislative. So this assists with the independence of the judiciary. As well as this, the justices who sit in the Supreme Court cannot be involved in any way in creating legislation, which was the case before. It could be argued that the Constitutional Reform Act of 2005 didn't really have that much of an impact on judicial independence, apart from the role of the Lord Chancellor and the creation of the Supreme Court. Because indeed, independence of the judiciary did exist before the Constitutional Reform Act. It was firmly established by such things as security of tenure. In other words, other bodies couldn't actually and can't remove judges from their positions. Their salaries are protected and don't have to be approved by Parliament, which is the case in quite a lot of state bodies. They have immunity when they're actually fulfilling their role, so they can't be sued for their actions. So that is a great deal of independence, and of course the Constitutional Reform Act hasn't added to this at all. They also had a great deal of independence in their role within judicial review. Within judicial review, they actually hold the government to account. They did before the Constitutional Reform Act, and they still do. So they scrutinise the government. Also, we think about the Constitutional Reform Act and the impact it had as far as case law is concerned. So we have to consider actually, was independence of the judiciary, and is independence of the judiciary actually a good thing? Is it something that we want to encourage, whatever the consequences of the Constitutional Reform Act? It could be argued that the Constitutional Reform Act of 2005 didn't really have that much of an impact on judicial independence, apart from the role of the Lord Chancellor and the creation of the Supreme Court. Because indeed, independence of the judiciary did exist before the Constitutional Reform Act. It was firmly established by such things as security of tenure. In other words, other bodies couldn't actually and can't remove judges from their positions. Their salaries are protected and don't have to be approved by Parliament, which is the case in quite a lot of state bodies. they have immunity when they're actually fulfilling their role, so they can't be sued for their actions. So that is a great deal of independence, and of course the Constitutional Reform Act hasn't added to this at all. They also had a great deal of independence in their role within judicial review. Within judicial review, they actually hold the government to account. They did before the Constitutional Reform Act, and they still do. So they scrutinise the government. Also, we think about the Constitutional Reform Act and the impact it had as far as case law is concerned. So we have to consider actually, was independence of the judiciary, and is independence of the judiciary actually a good thing? Is this something that we want to encourage, whatever the consequences of the Constitutional Reform Act? So next, paragraph 5. So in paragraph 5, we're going to say that in fact the judiciary never have and never will have complete independence. This is because they're actually subordinate, as we know, to the will of Parliament, that they have to follow the intention of Parliament when they're interpreting legislation. So independence, yes, but there are constraints. Yeah, there are constraints. Let's come to the conclusion then, paragraph 6. And we want to sum everything up as concisely as we possibly can and make sure that our conclusion relates back to the question. So yes, straight away in here, yes, there is a considerable impact of the Constitutional Reform Act. Certainly can be seen within the change of the role of the Lord Chancellor, the exclusion in part of the Lord Chancellor as far as the appointment system is concerned, and the creation of a Supreme Court, which led to the separation of powers between the judiciary and the legislative. So these we can see as adding to the independence of the judiciary. However, judicial independence was present before the enactment of the Constitutional Reform Act, and in fact the judiciary's powers have and always will be curbed by parliamentary sovereignty. Therefore, they will always have to follow the will of Parliament. So that actually acts as a conclusion for this question. What you do after you've completed the question is that you proofread your work, and you make sure that every paragraph you've included relates back to the question.